Good morning all. We are here today for the case of AFRINA versus Tech Innovations in Berhad concerning allegation of improper capital reduction through a share buyback. Ms. Hajar, you may present your opening statement.
Thank you, Your Honour. We are here today because Tech Innovation has in mind client which Ms. AFRINA View previously endangered its financial stability and trampled upon the right of its minority shareholders through an ill-conceived and potentially unlawful share buyback. This wasn't a strategic move. It was a raid on the company capital, leaving the cupboard bare for future growth and risking the very existence of the company. We will demonstrate that the buyback was not conducted in accordance with proper legal procedure for capital reduction, that it contravened the principle of capital maintenance, fundamental to corporate law, and has negatively impacted my client, which Ms. AFRINA's fundamental shareholder rights. We will also show how this decision lacked the commercial prudence expected of the board of directors.
Thank you, Ms. Hajar. Ms. Najiheen, your opening please.
Your Honour, Tech Innovations in Berhad is a thriving enterprise and the share buyback was a carefully considered strategic decision aimed at optimizing shareholder value and signaling confidence in our future. We will present evidence that every step of this process was meticulously followed in full of compliance with the Companies Act and the Companies Article. My client, Ms. Gayathiri, and the board act within their legitimate business judgment, prioritizing the long-term health and prosperity of the company. We contend that the plaintiff's claims are based on misunderstanding of corporate finance and disagreement with legitimate business strategy, not any breach of capital.
Ms. AFRINA, could you please explain your involvement with Tech Innovations in Berhad?
I've been an investor for 7 years, owning a significant minority stake, and I believe in their vision and growth potential.
And what prompted this legal action?
The announcement of the share buyback program. Initially, it sounded positive, but when I looked at the financial, I was horrified. The company, which was supposed to be saving for R&D and expansion, suddenly seemed to be draining its capital. The cash reserve plummets, and frankly, I feel misled. My right as a shareholder to see the company capital maintained were ignored.
Specifically, what concerns do you have regarding the capital depletion?
The financial statement prior to the buyback showed a healthy but not excessive cash position. Post-buyback, the position is precarious. It seems the board prioritized a short-term stock price boost over the fundamental maintenance of capital for long-term stability and growth. This is not just about my personal return, it's about the company's survival.
Ms. AFRINA, you mentioned concern about financial stability. Are you a financial analyst by profession?
No, I'm a retired engineer, but I understand basic financial health.
So your concerns are based on your personal interpretation, not professional and financial expertise, right?
They are based on common sense. When a company cash drops significantly after a transaction, it raised red flags.
Were you aware that the company sought independent financial advice before proceeding with the buyback?
I was aware they said they did, but I questioned the nature of that advice given the outcome.
Ms. Gayathiri, could you explain the board rationale behind the share buyback?
Certainly, the board believed that the company's shares were undervalued. A buyback was seen as a way to return value to shareholders, signal confidence in our future, and optimize our capital structure. We conducted extensive financial analysis and sought expert legal and financial counsel. We ensured that we had profit available for distribution and that buyback wouldn't compromise our solvency, adhering strictly to capital maintenance principles.
And what procedure were followed to ensure the compliance with the legal requirement for the capital reduction?
We consulted our legal team extensively. We ensured that the resolution was properly passed by shareholders, that the necessary solvency statements were prepared and filed, and that the company met all statutory requirements for solvency post-buyback. Every procedure for capital reduction was meticulously followed.
Did the board consider the impact of the company's future operations and stability?
Absolutely, that was paramount. The buyback was designed to be substantial enough to make an impact, but not so large as to jeopardize our strategic resources for R&D or expansion. We believe we maintain a healthy balance.
Ms. Gayathiri, you state that you conducted an extensive financial analysis. Can you produce the internal report showing the projected cash flow after the buyback, specifically for the next 12 months?
Those are internal strategic documents, confidential in nature.
So you are saying that court should not see the evidence that supposedly support your claim of maintaining capital? Were you aware of the projected downtown in our main market at the time of the buyback decision?
We considered various market scenarios as any prudent board would.
And despite these considerations, you choose to significantly reduce the company's most liquid asset. Isn't it true that shortly after the buyback, the company had to delay a crucial R&D project due to lack of immediate funds?
That delay was due to unforeseen market shifts, not the direct consequences of the buyback.
Thank you, Ms. Gayathiri. Given the arguments presented, it's clear we have a conflicting interpretation of the prudence and legality of this capital reduction. The court needs to further examine the detailed financial statements and the specific legal compliance steps taken. I will require both parties to submit further documentation regarding the solvency test applied and the profits available for distribution. We will reconsider in 2 weeks for detailed review of these documents and potentially expert testimony. Please adjourn for now. After carefully considering the evidence, arguments, and testimony presented by both parties, this court has reached a decision in the case of AFRINA versus Tech Innovation Sdn Bhd regarding the legality and prudence of the company's share buyback. The court acknowledged the plaintiff's concern regarding the depletion of company capital and its potential impact on long-term stability. Shareholder rights are a cornerstone of corporate governance, and the principles of capital maintenance must be strictly adhered to safeguard these rights. However, the court also recognized the defendant's argument that the buyback was conducted with the intention of optimizing shareholder value and in compliance with procedural requirements outlined in the Companies Act. The evidence provided, including the resolution passed and solvency test conducted, supports the claim that the board acted within their business judgment.